Good evening. I apologize for the delay. We were waiting for the other meeting to convert the recording. So if we could just please stand for the Pledge of Allegiance. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, we can call the meeting to order at 7:02 p.m. Roll call, please.
Mr. David Bradley.
I'm here. Do we do roll call in this meeting, but not the academic meeting? I wonder why. Is there
Mrs. Rita Spinelli.
Is there
Here.
Mr. Larry Stern.
Here.
Thank you.
So what's the reason for a roll call vote in comparison to the other meetings?
It's not a roll call vote. This is more of a meeting. The academic affairs really doesn't have any agenda items, no movement forward. Mr. Bradley is
No
more
official
of an information.
actions, you're saying?
Yes, it's more of don't take my words now and take them out of context.
Okay, so
This is more of a committee. The academic information is more of an information share. So.
okay, so this is a actual government committee meeting. Therefore, we're taking roll call. And you are an ex officio member, or are you actually a committee member?
Mr. Bradley, it's the same process we've been changing.
Okay, I'm whatever you want to call me, Mr. Bradley.
No,
Miss
what I want to call you.
Miss Spinelli, I see you are.
I'm asking what you
have your hand raised, Miss Spinelli.
Yes,
I'm
I
asking,
would just
why are you
like
cutting me
to-
off? Why are you cutting me off? I asked a question. Let Larry answer it.
Mr. Bradley, just let her go. Come on.
No, I asked you a question, Larry. You should answer it. She shouldn't cut me off, and Mr. Cleaver shouldn't cut me off. I asked you a simple
I'm
question.
a member of the policy committee.
Okay, so you're not the ex officio member as the president of the board.
Forget it. I'm not arguing with you on any points. Thank you.
It's not an argument. I'm asking a question.
Of course it is.
Miss Spinelli?
Okay, I would just like to say something before we get started. This is the 4th month of having a policy meeting, and the previous 3 we've had to call them short because of pontificating. And I am going to ask Mr. Bradley very nicely to please be civil, please be professional, please wait your turn, please raise your hand, please, once you've said something, don't repeat it 100 times, and try and stop with the insults. If you can't do that, I am going to ask Mr. Stern to please remove you from this committee as a member and put you on as an attendee. It's in your court, Mr. Bradley. Either you're going to behave or you're going to get put in as an attendee. You decide. Thank you.
And Rita, whose precious feelings would I hurt that would result in your use of an authority that apparently doesn't really have to banish me to being an attendee? So under whose rule and authority are you using this newly ordained?
Under Robert's Rules of Order for running a professional public meeting, rules you can't seem to adhere to. It's common decency, it's common sense, and Robert's Rules states that the members of the panel must maintain order. That's the authority.
Excellent. So I will have the floor for a second. I would appreciate not getting interrupted. And I'm
Well, you're going to get a few minutes, Mr. Bradley. You're not taking up the entire meeting. I want to hear the policies. I don't want to hear you. And that's what this is all about. So unless you're going to say something about the policies, I'm going to ask Mr. Stern to please put you in as an attendee. So your call. I told you, your call. You're either going to listen to the meeting the way it's designed, or you're going to be an attendee.
Well, at the beginning of this meeting, what we were doing is a roll call vote, Rita. And in that roll call vote, the first question was,
There was no
as part of the
vote.
agenda. Excuse me, am I being interrupted, Larry? Don't want to put you in the attendee list, right? You don't want to interrupt. Give me my 30 seconds. Our school policy says that the president is not a member of the committees. By exclusion, he is an ex officio member of the policies. So we're supposed to have 3 board members on this committee, Rita. I think we're making a mistake. I think we should correct that mistake. And Larry, as an ex officio member, should not have the right to vote on such items, but in the meantime, if he's going to pretend that he's a committee meeting member and not acting as the president, that's fine. I'm agreeing with that as long as he understands that that is his role. So I'm asking him to clarify
Recording
that
in
role.
progress.
So I'm asking him to clarify which role he's playing in this meeting so that we can have a civil meeting.
We
Thank
do
you.
not vote at committee meetings, Mr. Bradley. Nobody does.
Actually, we do. We make recommendations, Rita, on a regular basis.
That's not a vote, Mr. Bradley. The only votes that matter are the ones taken in a board meeting with the whole board present after they get a majority. A committee recommendation is not a vote. Now, Mr. Cleaver, could we please move on to the policies?
The first policy we have for first reading of policies, these are both new policies. The first one for discipline of students convicted of adjudicated sexual assault. This comes from Act 110 of 2020. It requires that all K-12 public schools are required to remove, transfer, or reassign students who are adjudicated delinquent or convicted of a sexual assault when the offending student and the victim are enrolled in the same school. Now, it doesn't say school building, it says school. So there is areas that have been questioned. This does come from PSBA, as we talked, as most of our policies do. This does put us in compliance with the new law that is in effect for the start of the 2021 school year. And again, this falls under, it's Act 110 of 2020. So this policy states, you could see that it gives you the definitions, what they consider sexual assault, what they consider the authority as well. So in the nutshell, that a student is convicted of a sexual assault with another student enrolled in the same district, they are required to notify the superintendent or designee of the conviction no later than 72 hours after the conviction. However, there is no penalty by the school district if we're not convicted. So it is in the policy, but I want the board to be, aware that if we're not made aware of it, of a conviction, not just a filing or a complaint, this is actual a conviction that we would need to be known within 72 hours. That is the responsibility of the student, or of course the student's parents or guardians, if this happens. So scrolling through, you could see some of the requirements that the school district is required to do once we're notified of this assault, if it does take place in this conviction. So we would be responsible to reassign the student to another school building, also, or alternate placement. So there is a lot of requirements within this Act 110 of 2020. And again, this policy, what this does is puts us in complete compliance with the state law of this requirement that is out there. Is there any questions on this policy for discipline of students convicted of sexual assault?
Why don't we have a copy of that 110, the new policy that came out in 2020, or the act that came out in 2020, so that we can review that against this policy that this board is writing?
Yeah, I do not have that up. You could do a search and you could bring that up at any time. But the Act 110 is amended of the public school code. So, and if you look under that, it's section 1318.1, students of a convicted or adjudicated delinquent of sexual assault. But I do not have that as part of the enclosures.
Yeah, that's the type of information you want to present to your board. But what was okay, so I got Act. The fact that we're not in a public meeting makes this more difficult, but if we can respect the fact that the Board of Education, these elected members, need information. So 2020 Act 110, and then what was the section you're talking about?
It was added section, it's 1318.1, and it should say students convicted or adjudicated delinquent of sexual assault.
Excellent. And then who wrote this policy?
This is from PSBA, as I said.
Okay, and since the PSBA wrote this policy, did anyone review this with our solicitor?
Looking at this, for this policy, no, we did not, because PSBA has all their legal authority to look at this before making a recommendation.
Well, I pulled this policy up in reference to other school districts that had made changes to the policy. And again, since we're not in a public meeting, it's hard to share that information with the likes of Larry and Rita. She might feel that's insulting, but it shouldn't be. But the reality is that since that's not available to us, I suggest and recommend that we postpone this policy and the adoption of the recommendation to the board, to our government board, this subcommittee's recommendation to a board, and wait until we have those that data. There's no current hurry to implement this at this time. We can do it next month after this board can make an educated decision instead of blindly trusting and rubber stamping the Pennsylvania School Board Association private lobby that we spend so much money with. I just said it once, Rita. There you go.
Mr. Bradley, again, this is the first reading, so we would be able to have that opportunity with the second reading. And this is
I don't even want to make it a first reading, sir.
This is my concern is that there's state rules and laws involved with this too. That if not having something in place because you don't agree with who puts it in or who writes it or who puts it in place could put the district at risk as well. However, I mean, that's up to the board, but I just wanted to make that aware that this is a new policy. So we currently do not have any policy that meets the Act 110 requirement.
And
Correct.
Mr. Bradley, I'd also like to say that, are you suggesting we use other people's policies from other school districts? Or, I mean, my concern is if we start with the one that's proposed and researched and vetted, if there's something we need to change, we can, but I'm not 100% sure. I'd like to look at everyone else's policies and make it according to them. Is that what you're suggesting?
No, that would be very naive to even think that that's what I was suggesting.
Any more questions
I
for
will make one though.
policy?
I'll make a suggestion, Rita, since we're on this committee together. In this policy, in the event that something is wrong and we harm a student, I mean, we've had issues within our own school district related to this policy. If we do harm a student because we have a bad policy and we do not take the time as the government board to review and correct that policy, would you feel either shame or guilt to the irresponsibility of not doing our due diligence prior to the adoption of policy? Or would you
Mr. Bradley, I read this policy, and as far as I can see, it's rather thorough. If something happens, this is a policy concerning students and sexual abuse. You're bringing up something that was never even brought up. It's done with, and this is if someone is actually convicted. So I'm just telling you, I read it, I'm fine with it. That's all I have to say.
So since we are privy to information from our administration, including copies of the invoices that were provided by our solicitor for the services that he provided, he has billed us for advice on sexual assault that we as a board have not seen the entire device. Please don't cut me off, Larry. We decided we're going to use Robert's rules. So since we do have invoices from our solicitor that is giving advice to the district administration and possibly some of the board members about sexual assault that may or may not have occurred, it had to have occurred within our district because of the fact that we're implementing the use of our solicitor for it, I would think that it would be most beneficial for our solicitor to be involved in this conversation, because we have some very pertinent questions related to the law and the accountability of our staff and the accountability of our implementation of this policy, because the Auditor General's report has shown us as a government agency to fail in our
Mr.
ability.
Bradley, that has nothing to
turn.
do
It
with
does.
this
Report has
policy.
I'll tie it
do.
up if you don't interrupt me.
I am interrupting you because I told you, if you can't stop saying things that aren't the subject of what we're talking about, I'm going to ask that you be put in as an attendee. This is your second warning.
Yeah, but-
One more, and I'm going to ask that you be put in as an attendee, because you cannot monopolize these conversations this way.
It's
You've
not.
made your point. I've made my point. This is a first reading. It will go farther than this. That's the end of it.
Well, it's not, because the Auditor General report was talking about the implementation of our policy. This is a policy, and we're going to try to implement it at some point. This is the first reading. Then our policy is to have 3 readings.
And that's a very far-fetched explanation of why we should be talking about this now. This is the policy. I say we put it out for first reading and hear what the public and everyone else has to say, not just you. And that's it. Can we please move on, Mr. Cleaver?
My vote is to postpone it.
Okay, I
If we
concur
do it,
with,
and Larry can make his vote.
I concur with Ms. Spinelli. that
We
move
don't
this
vote,
forward.
Mr. Bradley.
Remove this for recommendation to the board.
The next policy, again, this is a new policy regarding electronic signatures for districts. This is something, again, that is something we don't have. However, the e-grant system with PDE and some of the state level grants for approval, and a lot of the audits when we get to do require electronic signatures now. A lot of it is being done electronically, of course, with the pandemic, as you can imagine. They were not, many of the state auditors in different groups were not able to get on site and do the audits as they did. So many of the audits, for example, the Title I audit was completed virtually as well and on the phone. So we're submitting a lot of stuff back and forth. And so because of that, you could see where, electronic signatures would come in place. So the majority, I will say, if I had to put a number to a percentage of all the things that are required for us to sign or what have you, we'll have a physical signature and also have it printed underneath. But the e-grant system with PDE has moved to more of this electronic signature style. And again, a lot of those are handled through Mr. Tack's office as well. And so this is why we, PSBA feels it's important for a policy regarding electronic signature is there as well. With the electronic signatures, you could see that there's some, there's specific laws that still have to be in compliance when there is an electronic signature. So they may, for example, you may be required to do an electronic signature and also include a handwritten document with a signature on it as well. The grants, as far as being submitted, until they are approved, funding, especially when it comes to the ESSERS grant, which is a big one for all the districts, the funding does not come until that grant is reviewed and approved. So doing the electronic signature does speed up that process for payment as well for some of those grants. So that's where this electronic signature policy is coming from. And yes, this is a policy recommendation from PSBA.
Could you scroll down a bit, Mr. Cleaver?
Yes, sorry.
I'm perfectly comfortable with this policy because it is what most businesses do these days, even legal things. So I am fine with this.
With this policy, we will be required to, keep a log of electronic signatures. that are in connection with the district business with this. So we will adapt that as part of this policy as well too. So we'll have a log here, and administration Act 93 individuals are the only ones who would be required to sign something electronic wise, as it would be, required for board action. But with this policy, the district will begin maintaining a log for any type of document that needs an electronic signature. So we'll put the name of the document, who it was for, who it was submitted to, the date, and of course, who signed the electronic signature once this policy is adapted. Right now, we do not have this policy, but even without having the policy in place, we're going to start that process with the logging for electronic signatures.
I believe, is it my turn yet? Rita, can I have the floor, please? Rita, can I have the floor, please? Who's running the meeting?
Mr. Bradley, I'm not playing your games. You can speak anytime you want, just not forever and on the same subject.
Thank you, Rita. You're so kind. We decided we're going to use Robert's rules, and that would mean that the chair would present the floor to the individual. And since I'm the individual at the time, I would like the floor to be presented to me in accordance with that Robert's rule. Can we do that, please? Can the chair please hand me the floor? Boy, that didn't last long following Robert's rules. Okay, so on this policy, we're looking at electronic signatures. There is a glaring error, in my opinion, that whenever you have a policy, there's a section in which, if you can scroll up, Mr. Cleaver, because you can't see my screen, but it's the same policy you have. If you scroll up to where it says definitions, there you go, definitions. So in this policy, we have the definition of electronic record and electronic signature. And what's missing inside of this definition is the word district. So when we look at the district, we're looking at the Lehighton Area School District, I believe, and the Lehighton Area School District is made up of stakeholders, board, and then this subordinate administration that resides under the board. And then from there, you also have the solicitor and other parties, treasurers, and those other people. So the fact that this policy misses the definition of the word district, yet prolifically uses the word district, I think it would be an error to not have that defined. Secondly, when the board authorizes the use of electronic signatures in place of manual signatures, I'm looking under the authority to conduct district business. It is my understanding that under Pennsylvania School Code, that each implementation of a contract, each implementation of a bill, each implementation of a check has to go through a board policy first prior to the authorization of the district. To have this policy put in place without those checks and balances will lead us down the same rabbit hole that was defined in the Auditor General's report, where we failed to comply with Section 609 of the Pennsylvania School Code, where we failed to have an informed board review contracts prior to their implementation. Since this policy lacks those checks and balances, I think it should not be presented to the board as a first reading until such time that these things are addressed. The fact that the PSBA did not address these needs specific to our district after reading our Auditor General's report that described these weaknesses would be an error. Thank you. An immoral error.
Any other questions regarding the policy 800.2? Okay. The additional policies are the second readings of the other policies that we did attempt to, and so you had a long time to look at them. I do not want to read them verbatim, just ask, is there any questions from the first reading to now regarding any of these policies or concerns?
I would like to know, Mr. Cleaver, if you've had any comment from the public, from anyone outside of this committee, any comments at all on these policies?
I have not had any comments regarding these policies that are up for review. And again, just for clarification, the red is what is, of course, as you can see, being, eliminated, and the green is what is being added. And yes, these are recommendations from PSBA to be in compliance. The majority of them, I'll scroll back up to the agenda where you can see that the majority of them is based from our Title I federal grant audit that is, being completed now. And the majority of the 626s all meet that responsibility for the auditing purposes. So that's where those revisions all came into play from that audit and new policies as well. And that is in Title I, just as a reminder, is the federal. It's federal, that's not state.
I have a couple comments on section 113.1. However, as this is a committee and I am a public servant of the government, which is elected by the community, we have a community member that has their hand raised. They should be given the floor prior to any official action by our government agent. So I'd love to hear what, apparently there's a Jennifer Label that has her hand raised. I'd like to hear her comments first before I make mine. Thank you. Providing her with the floor by the chairman.
Is there any comments from the board? And we will go to them. Mr.
I do have comments, but I'd like to hear hers first. Thank you. I think it's within Robert's Rules of Order and my rights as a representative to listen to the stakeholders under our policy prior to me having to make a decision on behalf of their stakeholder input. Thank you. So please give the floor to anyone with their hand raised.
I just want to clarify again, this Mr. Stern or Ms. Spinelli, any questions for?
No, I have none on these policies.
I have questions, sir. Maybe you're ignoring the
Well,
concept.
if we're going to public comment,
We're not going to public comment. We're going to board comment.
Why don't you make your statements, Mr. Bradley?
Because I want the information. I want to use my board authority. I want to follow our policies. I want to make sure that I'm taking stakeholder input prior to giving my opinion. I mean, how much more wise can we be than to get the information from other people prior to making your own opinion? So my opinion is mine. I have some of it. I'd like to hear what these people with their hand raised would have to say so I can modify my opinion if necessary, because it is the elected board's opinion that makes these recommendations, and therefore I'd like to hear from them. And it's not public comment. This is comments specifically about any of these.
Bradley, this would be public comment. So we will go to public comment.
No, it's not public comment, sir. We are specifically not doing public comment. I'm physically asking.
This is public comment.
No, I got questions on the policy.
Hi,
review.
this is Jennifer Lively.
Yes.
So, somebody unmuted me, Mr. Cleaver. Am I allowed to talk
Yes.
now, or would you like
Yep,
me to wait at a different time?
We're public comment. Go ahead.
I'm sorry. I think I raised my hand, but I must have missed by a second. I just wanted to ask a quick question on the electronic signatures. And
Yes.
I'm sorry to go back to that, but my quick
that's
question
okay.
is, Mr. Spots brought up a athletic system that we were going to be using to launch and basically save the district money by having all these forms that were being copied or being able to go electronic. Would this electronic signature policy also apply to those?
This policy would just be for the district. Those electronic signatures would be from the parents of or the guardians of those individuals. So it would allow signatures to be permitted as part of this, but this specific policy does allow the district to have the full enforcement as it being signed. So the answer is it's more for administration. However, those electronic signatures for those files would allow this policy to take place, so they could be in full force and effect of the signature. So when you're signing off on the student, the parent forms, the physical forms and all that, with the electronic signature, that would be the same as, you know, a regular signature, that it's in full effect.
Wonderful. Well, I think that will help consolidate a lot of paperwork and time by administrative staff in copying and filing and all the above. So I just wanted to clarify. Thank you so much for letting me talk.
Yeah. And again, it comes in that for that, it's on behalf of the district. So the district has to sign it, and the parent, it would qualify.
Great. Thank you.
Does anyone on the board want to change their
Ms.
opinion?
Bose?
Wait a second. I was talking.
Bose?
Larry, wait.
I'm here.
Go ahead, Ms. Bose, or public comment.
All right, in the past, we have seen where staff members have signed contracts. Would that no longer be allowed? And would it only be administration that would be signing contracts, no matter what they might be?
When it is this policy for this type of contract, electronic signature, not so much a different contract, it would be administration.
I understand with the electronic signature, but are we going to move to policies that do not allow staff members to sign contracts? Because we have seen in the past where that has occurred. And my understanding was one of the issues with the Auditor General was not following through on contracts. So wouldn't it behoove us to have administration only signing any contract, whether it be electronic or regular?
Right. If it was a contract, a staff member, it should be administration. I'm not a staff member signing a contract, and this is where, is it agreement? Is it a contract? But with a contract, it should be an administrator. Actually, it should be, you know, either myself, Mr. Tack, or the business office, really, after the board's approval for the contract.
Right, but any agreement that spends money, wouldn't that be considered a contract, or should it not be considered a contract?
I don't want to say for everything. I think it has to be case specific for some of it. I think if it's, you know, a contract where you're agreeing to pay something that the board already approved, technically you're signing it and already approving it. Like if the board approves, for example, we just approved the Tremco program. So that signature would be signed, you know, by, you know, Mr. Spots or someone within that realm, or myself or the business office. So it's a contract that's signed, but it's after the fact of the board approval of it.
Well, the reason I'm asking this is because at work, we've had people sign for items delivered through UPS, FedEx, etc.
And we do have that, yes. Now that you bring that up, yes, we have people who are back in our maintenance custodian, or someone in the front office, if it's dropped off, would sign that is received.
Right. Well, that brought up some issues in the past at Giant, where then the things were not turned over to where they were supposed to go, and that put the employee at risk. So they have instituted a policy that no one can sign for anything. It has to be a salaried manager. And it's just something that I think that perhaps should be considered to protect the employee and also whatever is being delivered, but to protect the employee more so.
Yeah, that is actually a good idea, I suppose, with that. We do have.
I mean, it didn't happen often, but it did happen.
Right.
So.
Well, I know we did have different things that get dropped off here, and so depending on who the delivery person is, they could come to the front and drop it off. If it's larger drop off, for example, a case of paper, truckload of paper, they would do the count and then they would sign off. But as far as a policy for that, we don't have it directed to where like an administrator has to sign off. If the person is sitting at the front desk, if it's delivered to the buildings, would be the one who signs off, and then it gets delivered. A lot of times things may get delivered here and then it goes through inter office mail if it's something that's dropped off for another building. Most of the times they're dropped off at the building levels, but sometimes depending on the driver, they may drop, for example, a sample textbook, for a department head. May come in here for delivery. We would sign that we received it, and then we would put it in our office and send it to that individual.
Right, because they wouldn't be able to go into the
Right.
school to deliver it. I understand that, but I mean, certainly, it's something to consider, whether it's over a certain dollar amount, whether it's, whatever, that perhaps the department head should sign for it, or,
Mhm. The
just something to consider, because I know we've had issues in the past, so.
the majority of the things that get delivered here, if no one is in the back to receive it and sign off, they will come up front, and then an individual here in the central office will go back and check it off, that it was received, especially when we get supplies and those type of things at the beginning of the year. And that's usually handled right through the business office, where they'll go back there and actually physically check off that they received what they said they were to receive.
Okay.
Thank you.
Okay, so back to the policies that I wanted to discuss. Can you please go back to 113, please, Mr. Cleaver?
Yes, sir.
And if we're going to follow Robert's rules, we should probably get everybody a copy of them so they can read them, because
They're
what just
online,
occurred.
Mr. Bradley, and they just have to click on it, the link, and
well.
right to the board docs, and they can see.
No, I said Robert's rules, sir. Robert's rule. If we listen to the participants, what we're talking about, having a discussion of each of these policies with the people, and Rita was very eloquent in her understanding that nobody in the community has provided this government agency with input on these policies. And I think it's because of the draconian methods to which even Rita would like to silence a board member and punish me.
Mr. Bradley, can we please have your question on 113?
So 113. Yeah, that's fine. I just wanted to make sure we understood why we're
because
having
this is
discussion.
what we're talking about, Mr. Bradley.
It's a shame.
Please make the comment on the
113.
policy.
So let's look at 113. Go down to authority, please. Now, once again, the board directs the district. So the definition of the word district should be identified here. Is it the board directs the administration? The board directs the superintendent? The board directs the whom?
It is the entire district, Mr. Bradley, that is responsible for implementing anything with special
entire
related
district.
IDA.
Right, so the entire district. So who is the district? Is the board the district? So we're directing ourselves? Are we directing our administration? Who are we directing? Because
Mr.
it says the board directs.
You're directing the district, Mr. Bradley, exactly what it says.
It's not exactly what it says, but that's fine. We can differ in that opinion. Let's go down a little further. So it says, however, under certain, now let's back up actually to preview why this is important. The Pennsylvania State Department of Education has already chastised our district for its inability to advance students with disabilities to the level of their standards. And
Mr. Bradley, there was no chastising. The department and the state is working with the district to help improve, which is really what the goal of the school board member should be, as yourself, to work with us to help improve this. So don't please say that we were chastised. We were not. We're doing everything in our power to make sure that we are meeting the needs of not only the ones who didn't meet the standards, but the ones who did, and to continue to move them forward. As we said before, our focus is on growth of these students and trying to get them ready. So please don't put words in the State Department of Education, because they did not chastise us. They are working with us, is which I wish is what you would do.
And I'm working with this because we're going to adjust these policies. I'm on the policy committee meeting and the academic affairs meeting. So as a individual that can use my own words, you don't have to correct them because they are mine. I believe that the Department of Education put us on a list of almost 200 schools that were chastised for failures, substandard educational results. And that list is called an ATSI list. And with that list, it was very specific in our regard to students with disabilities. Now, luckily, we're not chastised for all the other areas of the report, but most definitely heightened with other districts in the state. About less than half were chastised for this students with disabilities weakness. So when we look at this and we're giving this authority, it says under certain circumstances, a student may be placed in an interim alternative educational setting by school personnel or the IEP team. So now this is the board allowing this administration that has already suffered from issues related to students with disabilities, if appropriate, change the student's educational placement to one which is more restrictive than the placement where the misconduct occurred. So in this understanding of adopting a policy to ensure that we have free and public education, I don't believe the board should authorize our administration that has accepted the state's help in correcting the failures that we've had within our district for these students with disabilities. And I've witnessed the IEP team having litigation about providing students with disabilities educational benefits. And what I've witnessed is some of those litigation efforts can take months, if not years, to resolve.
Mr. Bradley, please understand what you're even trying to discuss.
I'm trying to discuss.
This is nothing to do with what we're on the improvement plan for. That is strictly academic. This is based on behavior. Nothing in this is related to academic. So please don't confuse the two.
I am not. I'm surprised that you would, but I do believe.
Mr. Bradley, this is not dealing with a student who is struggling educationally. It is about a behavior issue. That is what these changes in alternate placements are directed at, not about a student who is struggling academically. That is the area to where we need to show more growth with those students at the high school level, and really all together, even because we didn't meet the requirement, because we don't have the large enough caseloads at the lower levels, because you need to have a certain number of students to meet the subgroup, and we do at the high school because it's a combined group where the other ones are by grade level, and it does not, we don't qualify under the subgroups. So really, even though we're on improvement and working to improve at the high school level, as we said, we're starting from the bottom and still making a K-12 initiative. But this policy is related to discipline.
Yes, and it would be remiss of you and this board to allow such an excuse to be applied to our district, in my opinion, because if you look at our disciplinary actions for all students and the population of students and the bell curve of those disciplinary actions, and you look at a student that might have disciplinary issues related to their academic performance, I feel that the data will prove that they're related. On many occasions, students that are struggling academically might also end up in disciplinary action. This is part of the training that is missing from our district as a whole for the social emotional learning process, where you can look at the disciplinary actions or the acting out or the concerns of a student in relationship to their academic struggling and needs. They're related. Whether you like it or not, studies say they're related. So I think they're related. And I don't think that we're having a policy here that allows the district board to provide the right amount of oversight over top of our administration so that we can protect these students with special needs and disabilities, specifically disabilities, to ensure that they receive all of their free and public education benefits and make sure that we're meeting the standard. We should be above the standard. I don't want to be on a list of 200 other schools out of 500 that fail. I mean, locally, Jim Thorpe isn't on that list. Palmerton's not on that list. Weatherly's not on that list. Yet Lehighton is on the list of, as you put it, seeking state assistance and doing our job. We should be above the standard. We should take pride in our district. So I think this policy should be properly reviewed specific to our district because of our problems and because of the way that it's important for our government board to not only just write and rubber stamp these policies and shove them through in a blind trust, but actually apply the policy and hold the administration, not the district, but the administration that this board hires to a standard, hold them accountable, measurable, with a metric to ensure that the goals we're aiming for are the goals we meet. And once we set up a goal, if our policy decisions do not meet that goal, we can change them. Currently, in my understanding, that this district has failed to meet the basic goals of protecting our students and met the goals of saving our community. We're spending money on IEP litigation. We're spending money on hazing issues. We're spending policy issues
Okay,
about,
okay.
hold
Now
on,
we're gonna
about the
stop that.
BHA.
Please,
Hold on.
please stop that.
No,
Please
you're
stop.
moving things over to the
Okay,
BHA. These are disciplinary.
Mr. Bradley, you are off topic big
Oh,
time.
really?
And
By whose
Mr.
opinion?
Cleaver, would you please put him on mute?
Oh, yeah, put me on mute. Throw me into the attendee spot.
Are there any other
Please make me an attendee.
questions for public
Violate your
comment
rights.
on the
Violate my
agenda?
rights. Go for it. Please violate my rights, Rita.
At this time, there's no other questions.
Get
from
another court order
public
out there.
comment.
Well, now it's the time
There
for
are
public
no other
comment.
questions.
No,
on
Well,
public-
now is the
public
time for
comment.
public comment, sir. If you're going
Move
to
to-
Mr.
follow the
Bradley,
agenda and
I
Robert's
don't
rule,
need your approval for.
No.
you don't need my approval,
There
but
is no-
Larry does. He's the committee
No, I
chair.
don't
There
need
is
your
no
approval
other
for anything,
comments.
sir.
Yeah, well, apparently
Under
Rita
public
needs the
comment.
approval to get people in the
Thank
meeting.
you.
Thank you.